Manchester Ship Canal Company Ltd and United Utilities Water Ltd, part heard.
Thank you.
Please, Your Ladyship. I was dealing with cases which were raised by Learned Premier Mr. Hart and the interveners, and I'd come to the case of Bowden and South West Water Services, referred to by the interveners. It's in the authorities bundle, volume 2.3, tab 49, at page 572.
And what's said to be the relevance of Bowden?
Well, the relevance of it is that there is a dictum of Mr. Justice Carnworth referring to section 117, subsection 5, which I'll take your ladyship to in a moment. But there's also, since we have it open, a short statement which may assist in summarising my answer of yesterday to the questions that my Lord Justice Arnold asked about the role of the Environment Agency, which it's probably important that I show the court simply to have probably a more succinct summary than I gave the court yesterday.
Thank you, Mr. Karras. I should have said to Lord Justice Arnold, I hope you can hear us. I think he would have complained by now if he couldn't.
You're absolutely right, and I can hear loud and clear. Thank you.
Okay.
So I can deal with it. I will deal with it very quickly. It was a case of a mussel fisherman. He complained about pollution from sewerage systems. He pleaded nuisance and Rylands and Fletcher and alleged various breaches of EU law and domestic law. There was an application by the defendants to strike out the claims based on statute, but there was no strikeout for the common law claims. So to that extent, where it says nothing of particular interest. However, if I can take the court first to page 580 to 582, where the statutory scheme is described by Mr. Justice Carnworth as he then was, but in particular, I don't think the court need read the whole of that now, but it's a description of an earlier iteration of the statutory scheme before the Environment Agency came on the scene. But on page 581, Mr. Justice Carnworth sets out a passage from a judgment of Mr. Justice Harrison in Morton, where he refers to the role of the NRA, which is now the EA, and refers to the NRA being involved in the engineering solution to achieve design standards. The NRA is involved in that design process, which is an iterative process, in order to satisfy itself that the water company's engineering solutions will achieve those standards. So one sees there the NRA being involved at a number of levels, and has been since the early stages of the statutory scheme.
So it goes through the NRA, now the EA. Before it goes to Ofwat.
Well, there are the passage we're looking at here is dealing with permitting. So what we're looking at, the Environment Agency is involved at two levels. At the higher level, there is consultation when one is considering what is needed for funding purposes to provide the infrastructure necessary for, as far as the EA is concerned, environmental improvements. But they're also involved at the day-to-day level of looking at each outfall and the improvements needed, because permits are needed from the EA to discharge polluting matter into watercourses. So they're involved at two levels, and of course their involvement at that day-to-day level feeds into their understanding of what they will say the environmental improvements that need funding will be at the AMP level. So,
but the ultimate decision on that's a decision for Ofwat.
The ultimate decision on funding is a decision for Ofwat. The ultimate decision for what is permitted under the permitting regulations is for the EA. But that's really I draw attention to that because it's a succinct description of what I was trying to explain to the court in answer to my Lord Justice Arnold's questions, but the passages to which the interveners refer appear to be at pages 585 to 586, where there's a general comment on the UK provisions, and in the second paragraph of the sidelined section, secondly, there's an express reference to section 115, and Mr. Justice Carnworth says section 1175 of the WIA does no more than make clear that the provisions to which it refers do not create any statutory immunity from liability for the actions referred to in paragraphs A and B. But of course, we say two things. Firstly, this comment was pre-Marchich, and secondly, Mr. Justice Carnworth made no finding on the extent to which unauthorised matters, unauthorised as a result of section 117, might or might not be actionable at common law. So it takes us no further, but it was referred to, and I have to deal with it. My lady, the next case, which was referred to, and it was referred to by my learned friend Mr. Hart, is British Waterways Board and 7 Trent, and in particular he took the court to the extract in the judgment of Lord Justice Keane. That appears in volume 2.3, the same volume at tab 50 at page 596. The court, of course, in that case, as your ladyship pointed out, was dealing with a different and far narrower question than the question that's being dealt with here. The material passage in which the effect of section 1175 is considered is in the judgment of Lord Justice Keane, which is on page 621, paragraph 84. He refers to both provisos and says they're designed to ensure that those who may be affected by discharge, but those whose consent to the discharge itself is not required in terms of property rights, are nonetheless clearly protected against damage. Into such a category would come those downstream of a discharge, and so forth. The provisions in question are there to make it clear that their common law remedies, particularly nuisance, are not affected by the exercise of the statutory powers referred to. The simple point is that this case is pre-Marchich, and the questions raised in Marchich were not addressed or considered by the court. And we say as well, it takes no account of the reality that the undertaker can in fact do nothing to prevent new connections, so building new sewers, so where new sewers are, so without building new sewers, they can do nothing to prevent the discharges. So it's a dictum, and I respectfully submit can't stand in the light of subsequent House of Lords authority. Mr. Hart also referred to the earlier Manchester Ship Canal case in the Supreme Court. I won't ask the court to take that up. There was nothing argued about the Marchich point, which we're considering now in that case. None of the passages to which Mr. Hart took you answer the question of what remedies are available. And I respectfully submit upon rereading, it is clear that Lord Sumption was not going anywhere near asking or indeed answering the Marchich question in relation to what remedies might be available in the event of a breach of the provisos, albeit, as we say, there are remedies, though those remedies are either under section 18 or under section 95. As both under section 18 and section 95 should a remedy provided under the law. So that deals with the authorities and what was referred to as the rich jurisprudence. And on this point, all I propose to do now is just tie up some loose ends by going to my learned friend's grounds of appeal. There are a couple of points with which we haven't dealt, and I hope I can deal with this in about 5 minutes before moving on to the consents point. I think the authorities can now be put away. If the court could take up a core bundle, the grounds of appeal appear in tab 2. Actually, it's most convenient to look at them in the skeleton argument at tab 2. Ground 1 is set out at page 21. There appear to be, we've discerned three points made within this first ground. The first suggestion is that a discharge in contravention of the proviso is not necessarily a failure to remedy a duty under section 94(1). We've dealt with that already. We say the answer as a matter of plain language is that if one is discharging polluting matter into a watercourse in breach of the provisos, one is inevitably, as night follows day, not effectually dealing with the contents of one's sewers. Secondly, it is said that independent remedies survive, and they refer to section 18.8, but I've made my submissions on that, and I don't think I can add anything to what I said yesterday. And the third ground of attack appears to be that there's no incompatibility with common law remedies. We say that is misconceived for a number of reasons. First, as was pointed out yesterday during the course of argument, indeed by a lady, the Marchridge case in terms was a case where damages was sought, and it's a case where the whole claim, including the claim for damages, was precluded. So the simple point is that if the Marchridge decision applies in the case of breaches of the proviso, which we say it does not matter whether the claim is framed in damages or not. We respond more fully in our skeleton. It may be quickest to turn that up. It's at tab 4 at page 64. We make the point first that the judge is right for similar reasons to the ones I was saying. I was urging on the court yesterday. Damages itself undermine a claim for damages itself undermines the statutory regime, which is ultimately all about funding infrastructure and setting priorities. There's also the point, picking up at the point about the jurisprudence on damages in lieu. Before one gets to damages in lieu, it's now well settled that the jurisdiction to award damages in lieu is predicated on the court having jurisdiction to award an injunction. We've referred to a passage in Lord Newburger's judgment in Coventry and Lawrence. There's a better statement of the principle in one of the cases to which I took Lord Justice Arnold to be referring yesterday, the one-step case, which isn't in the bundle. My learned friend Mr. Hart is going to be handing it up later. I simply refer the court, the court needn't take it up, to the passage in paragraph 95.3, where Lord Reed says this: Damages can be awarded under Lord Keynes's Act in substitution for specific performance or an injunction where the court had jurisdiction to entertain an application for such relief at the time when the proceedings were commenced. Such damages are a monetary substitute for what is lost by the withholding of such relief. So if injunctive relief is precluded by the statutory regime, damages in lieu would also be precluded, we say, because an injunction is precluded.
Your point is that Marchich doesn't say you could in theory grant an injunction, but as a matter of discretion you shouldn't. It says you can't grant an injunction.
Exactly. That's the second point. The first point, of course, is the one that it applies to damages for the wider reason that even an award of damages is in essence an undermining of the system. But the second point in relation to damages
some of Mr. Marchich's claim was for common law damages for past loss, not Lord Keynes Act damages for future loss.
Exactly, and even those damages, the extent to which he was out of pocket.
He spent £16,000 on building a little fence around his garden.
And that's an even harsher result. He was not entitled to claim for the extent to which he was actually out of pocket, leaving aside negotiating damages. Though it's been mitigated by the
compensation scheme. Yes.
Exactly. And that's how we say it. So that's all I need to say on that. We've set out our points in the skeleton argument. The second ground, going back to page 30 in the bundle, there's a criticism of the reasoning in Marchich. Ground 2, we've dealt with that, and I don't propose to go over old ground. Ground 3, which is on page 32, is a similar point to the intervener's point that the provisos would be OTOs. Again, I've dealt with that, and I don't propose to add anything. At ground 4, on page 35, there's an additional point which I don't think I have dealt with. They say that there's a distinction between a discharge and an escape. I think as we understand it, the essence of the case seems to be that they're saying that a CSO is designed to have a polluting effect, therefore we should be liable. I think that's the point. This, however, we respectfully submit misses the point for 3 reasons. First, we inherited the CSOs about which we're talking on privatisation. There's no allegation that the CSOs, when constructed, were negligently designed or built. And the complaint is fairly and squarely that we must improve the infrastructure. This is a case within Marchich. If they had been negligently built, that would be a different matter. We might be a case analogous on the facts to Jones and Van Rust. That was under a different statutory scheme. But we say it doesn't matter whether we're talking about discharges or escapes. If what comes out of the sewer, which causes the problem, results from an inadequacy of the discharge, which can only be remedied by the provision of further infrastructure. That's my answer to ground.
Can I just ask you, nothing turns on it, but just a matter of interest. This system of having combined drains for rainfall and domestic sewage, that seems to be one of the causes of problems, because in dry weather, the sewage, your system can cope with it. It only can't cope with it when there's heavy rainfall. That's obviously the way in which it was designed in Victorian times. Is that unusual? Is the UK unusual in having that system? I mean, there doesn't seem to be any obvious reason why rainfall and sewage have to have the same set of pipes.
Oh, they don't have to have the same set of pipes, but of course, when one's dealing with the combined system, as we point out in the evidence, and of course in Victorian times, measurement of pollution was far less sophisticated. That which was discharged from a combined system, as we explained in the evidence, was heavily diluted. So one suspects in Victorian times it was considered that the level of pollution was considered to be acceptable because of the dilution by the rainwater. That would be my inference from the way these matters are designed, and the fact that we know that environmental protections have increased dramatically since Victorian times. Yeah.
I mean, you could, in theory, design a system in which you have one set of pipes for sewage, which was always adequate, and a completely separate set of pipes for surface water drainage, and then you wouldn't have the problem.
Yeah, and indeed that's the way it works now. But it wasn't considered to be a sensible, cost-effective way of doing it in Victorian times. One infers, and as I've indicated, and as indeed the evidence indicates, what comes out of these sewers is screened and heavily diluted, which in Victorian times was considered to be sufficient.
Well, also, I think, when Bazalgette built the London sewage system, it was intended that its combined storm overflows would only be used once or twice a year.
Yes, and of course we've had climate change plus increases in built.
I think the main problem is that land's been built over, so it doesn't drain into the ground.
Well, exactly. That was the point I was about to make. So now we have sustainable urban. Sustainable.
More surface water because less soaks in.
Yes, and there's a whole regime now designed to deal with that, which we needn't trouble the court with.
In London, we've got a brand new sewer being built. Precisely this problem, but it doesn't look as if you're doing the same in the Mersey.
Well, we are upgrading incrementally, and one sees from the evidence the significant number of intermittent discharges which have been taken out of the system by improvements over the past 30 years or so.
Okay, sorry, that was a bit of
No,
a distraction.
it's important to understand the context. So I don't. While a distraction, it's not unimportant. The point being that, of course, when built, these were considered to be adequate. This was the way of dealing with sewage. Obviously, it wasn't considered in Victorian times that which came out of combined sewage outfalls would have been prejudicial.
Can I just take you back to ground 4, which is about whether the discharge is involuntary? And in relation to that, you said the discharge stroke escape dichotomy doesn't get one anywhere. You inherited the CSOs, and there's no allegation of them being negligently built. It's therefore a Marchich situation. Do you say anything else about whether it's involuntary or not?
In my submission, it takes the matter no further. We pick that up dealing with ground 5, where they make the point that the judge got it wrong on whether it's trespass or nuisance, and it's in that context we deal with it. There seem to be 2 points made in relation to that distinction. First, there's a suggestion that Marchich is limited to nuisance cases, so it doesn't extend to trespass. And secondly, they're saying that discharges from sewers in breach of the provisos result in trespasses rather than nuisance. We respectfully submit it makes no difference whether it's a trespass or a nuisance. What one's concerned with in the Marchich situation, or rather when asking the Marchich question, is with what is the remedy, and the remedy for the sort of trespass, if it were a trespass that was being considered here, would primarily be an injunction. But if one needs to consider whether it's a trespass or a nuisance, one has to go back into the mists of time.
Well, just before you go on, Mr. Karras, can I just ask a quick question about that? And I appreciate you've been diverted onto ground 5 here, but since we're discussing the issue, it's probably appropriate to ask the question now. One reason why conceivably perhaps it might be of interest to know whether it's trespass or nuisance is that if it's trespass, we're talking about private property rights. And at least one level, encroachment upon private property. Whereas nuisance doesn't necessarily involve that.
Well,
and that's a potential point of distinction between the two.
with respect, when one's considering a claim for private nuisance, and that is what we're considering here, a claim for nuisance is an interference with a property right. There are two sorts of nuisance. There's an unreasonable interference with the enjoyment of property. That's if I make too much noise, for instance, and your lordship is your lordship's enjoyment of his own house is affected. Then there's the interference with an incorporeal hereditament, which is usually regarded as actionable per se, just as trespass is. And the reason.
Really? I thought if you interfered with an easement, it had to be a substantial interference.
It has to be a substantial interference, but once that is established, there's no need to prove damage. Damage has been held in a number of cases not to be the gist of the action. That's what I mean. The interference has indeed to be substantial, but one then doesn't have to do, as one does in other forms of nuisance, plead damage, arguably at any rate. But the point being, going back to the old forms of action, a claim in trespass originates in the old form of action, an entry v et armis, I'll come back to that in a moment, which inevitably involved some willful, voluntary or negligent entry onto somebody else's property. That, of course, is not the case with nuisance, where one can cause a nuisance by one's involuntary act. So one brought an action on the case for that sort of interference. And the reason why one brings a claim in nuisance for the interference with an incorporeal hereditament, of course, is that it's not an entry into property. One's not interfering with possession, that one can bring a claim for possession, a claim in trespass against a profit a prendre, which is a possessory right. So, as I said, we can get into the detail. We've got a couple of cases which make that distinction.
Before we get into the detail, can I put a very simple proposition to you? If I build my roof so that the water from the roof discharges onto your property, that's a trespass.
Well,
is it not?
It might be.
How might it not be? I'm deliberately putting in place a bit of infrastructure which is discharging water onto your land without your permission.
Can I make a slightly? I'll come back to that in a moment by making a slightly starker distinction on the facts. If I have a bucket of water and throw it onto your lordship's land,
that's a trespass.
That is clearly a trespass.
Right.
Now, in the case of the roof, if I design it so it discharges onto the land, it might be a trespass. Well,
you've got to be able to stop it, because if you don't stop it, after 20 years, I get a prescriptive right of eavesdrop.
Yeah. Well, yes, but one can quite so. But that, of course, one can acquire a prescriptive right to cause a nuisance, and that indeed is established in.
Well, certainly, Lord Sumption thought that directly discharging water from your land onto someone else's land is prima facie a trespass.
But in the case of sewers, of course, in the case of a sewer, which one has not oneself built, but which one has.
That's a different question.
Well,
at the moment, I'm looking at the person who builds it.
Well, the person who built it, yes. Then he, as I said, he might be in the position, and probably is in the position of the person who has the bucket of water throwing it on somebody else's land.
Right. Now, suppose I build this house which discharges water onto your land, and I sell it to someone else. Are they not also guilty of trespass, so long as they leave it there?
In that situation, they might be, but then we say there's a ground of distinction. If the roof is built in a way that water doesn't discharge, given let's say the climate, the rainfall isn't so heavy that the gutters overflow due to climate change. The climate results in more rainfall, so the gutters now discharge. with respect, I think we might be in a grey area. I'm not sure it matters. It doesn't matter for the purposes of my submission. We say that
your argument is the successive householder might be able to do something about it, but you can't do anything about it, and it's in that respect that it's involuntary.
Yes,
that's the argument, or rather, not you can't do anything about it, but the only way you can be made to do anything about it is through the section 94 process.
That's the real point. We don't need to get into the juridical differences between nuisance and trespass, which are difficult, and there are fine lines. As I said, there's the clear case of building something, which is in effect, which is doing no more in essence than throwing a bucket of water on somebody's land quite intentionally, and then finding oneself with land which, due to changes of circumstances, results in, or even not just land, infrastructure, which, due to changes in circumstance, then starts to cause a problem. That could be that we would say is more likely to be on the nuisance side.
But your real point is it doesn't matter, because of the marchage. If you're right on marchage, it doesn't matter if it's trespass or nuisance or anything else, you can't complain of it in a private action.
Exactly.
That's your real point.
There is on the pleadings an issue which wasn't to be dealt with at this stage as to if it's actionable at all. Is it a trespass or a nuisance? And that actually on the pleadings is for a later stage. So I'm certainly not urging the courts to deal with that at this stage. Though I hope I've explained to the court that there can be a fine line between whether there is a trespass or whether there is a nuisance. And in this particular case, without looking at the particular facts of each outfall, I wouldn't ask the court to make it.
So what you want us to do is to dismiss the appeal, and if the appeal were allowed, and we thought the marchage point wasn't a complete answer, the case then trundles on for findings as to whether on each outfall it is a trespass or a nuisance, and that might depend upon all sorts of facts which are not before us.
Indeed, and that's the way it works on the pleadings.
Thank you.
Now, I won't take the court to those cases, but for your lordship's note, there are dicta in the National Coal Board and Evans case, which is a volume Authorities 2.2, tab 39, page 303, and there are again dicta in Public Transport Commission and Perry, which is Authorities 2.2, tab 44, page 273. Again, there are dicta. We haven't dealt with them in the skeleton argument, but what one sees, going back to the old cases, the distinction between actions viet armis and actions on the case.
Okay.
But that, we submit, is either ended by our interpretation of marchage or for another day. So if I can turn now to the licenses.
Do you want to say anything more about the interveners, Skeleton? Or have you dealt with everything?
I think we've dealt with everything that the interveners raised. We've dealt with the meaning of marchage, which is a point they make. We have dealt with the rich jurisprudence, which is the point which they make, and we've dealt with the proviso being said to be OTOs, and we've explained that it has a function, albeit a different function from the proviso in previous legislation.
Yes, there was one point they made, a sort of introductory point, saying that this is a very unsuitable case to be a test case for something which will apply throughout the country and will lead to sewerage undertakers being able to pollute hitherto pristine streams.
There's with respect, we don't understand that point because the whole
nothing in your argument enables you to build new outfalls. It's all to do with pre-1991 outfalls.
Well, that's not right. The pre-1991 point it is limited simply to the license. The proviso applies to all our sewers, but of course, when we build new sewers, they are built to standards which must comply with what the Environment Agency requires of us, and they are built having been approved.
Having gone through the off-what process.
Having gone through the off-what process.
And the permit will be
And of course, my Junior points out, since 1991, we have no automatic right of discharge. So if and to the extent that private rights are affected, we have to acquire those rights by compulsory purchase. So there'll be so if those rights, if there's an objection, there's a whole public inquiry process that has to be gone through. Indeed, we went, as you may have seen from the agreed statement of fact, there's been a whole public inquiry process gone through in relation to another outfall into the canal.
But it does follow from your argument, does it not, that if you build a new sewer today, having gone through the Environment Agency permitting process and the off-what financing process and any public inquiry and got all the licenses, once it's there, then if in the future building means it becomes insufficient and you discharge polluting matter, the only remedy will not be a private law remedy, but will be the remedies provided under the
It'll be the remedy.
process.
It'll be the remedy through the statute. So we say there's nothing inherently wrong with that. But of course now, unlike in relation to our inherited infrastructure, there are levels of safeguard in relation to the new infrastructure which didn't exist in relation to that which we have inherited. So in practice, we are concerned with old infrastructure, and there's nothing. Indeed, I respectfully submit one might say the case is strengthened in relation to having only statutory remedies in relation to new infrastructure, because one clearly has those additional safeguards.
But to be clear, therefore, your argument does not depend in any way on the fact you inherited this structure rather than built it.
No,
that's exactly the same.
The same argument would apply, but as I've said, in relation to new infrastructure, we have the additional string to our bow that there are additional procedures to be gone through at a number, well, at three levels. There's the environmental permitting level. There's the we need to acquire the rights level, because we would then have to either agree or go through potentially a public inquiry process if there was an objection. And there's the off-what funding level. And we say there's nothing inherently difficult with that, because of course if rights to discharge are acquired by compulsory purchase, there is compensation.
But exactly, that's why the whole question doesn't arise for new infrastructure, surely. It's precisely because, as you explained, you have to acquire the rights, and you either do it consensually or you've got powers of compulsory purchase.
But
so I can't see how the issue would arise with new infrastructure.
Well, it can arise in the circumstances which my Lord Justice Nugee suggested. The proviso still applies, and it is conceivable that over the years, over the decades, the existing infrastructure, which has been promoted through the new scheme, becomes inadequate. Of course, it's very unlikely to happen overnight, but one might see 10 or 20 years' time that things will change.
Thank you.
My Lord, my Lady, if I can go on to the next point, we didn't understand Mr. Morgan to have abandoned his point that the licenses were statutory consents. You've seen that is in issue both in the grounds of appeal and the skeleton arguments. We'll deal with the point, as we used to be allowed to say, de bene esse, before we consider whether or not the judge was correct to refuse the point to be taken, and I'll deal with the procedural point at the end. but because we have to deal with the question of whether or not these were statutory consents, to knock it one of the points on the head, I do need to spend 10 minutes or so just looking at the agreements themselves, because they undoubtedly will need to be considered when judgments, in the process of giving judgment. The first agreement is in volume 2 of the core bundle, tab 25, page 601. I'm sorry, that might be wrong. 494. Yeah, I've got my first instance notes in front of me. This relates to an outfall which we've numbered 23. It's only an unsigned copy of the document that we've got. We haven't admitted that this document is enforceable at all, but that will be for another day. The document provides for an outfall pipe to be constructed at a particular location to discharge stormwater into the canal, and there's a rent of 1 shilling, and there's a provision for termination about halfway through, and we further undertake and agree upon 6 months' notice in writing.
Sorry, Mr. Harris, you said 1 shilling. I'm reading £1, 1 shilling. If I'm reading wrong place.
You're quite right. It is £1, 1 shilling. There's a provision for notice to be given. We further undertake and agree upon 6 months' notice in writing from you, the company being given, which notice may be given at any time and shall cease on the last day of any month in any year. And there's a provision further down requiring the removal and putting to an end of the permit and the removal and discontinuance and exercise of the enjoyment and the reinstatement. Then on page 498, starting on 499, you have a slightly longer form of agreement between Runcorn and Canal. This relates to the outfall we've called 26. It permits the council to lay a storm overflow subject to various conditions and an annual rent. The relevant provision for termination is on page 500 and sees there's a provision for 6 months' notice and a provision requiring removal, discontinuance of exercise and reinstatement.
Have these rents been paid?
We're not sure. Yeah, I think I now recall what happened. Of course, it's now claimed that the licences are at an end, so they haven't been paid since those which have been determined. I think payment does go on, albeit at a small.
You ought, consistently with your case, to be tendering the payment.
But I recall many years ago, because as the court may have anticipated or picked up, I've been involved in this case for a long time. There was discussion of tender, and I believe we consistently did tender, but in relation to those where the agreements have been determined, the tender has been rejected.
And this one is 5 shillings on page 500.
This one is 5 shillings. Then on page 505, we now have a slightly more sophisticated form of agreement between Warrington and the Ship Canal Company. It relates to an outfall we've called 55. On page 505, it's described as the demise of a right and liberty. in respect of stormwater overflow sewer. It permits the corporation to lay and use a storm overflow drain into the canal for a rent of £3.03. The demise is expressed to be terminable on 6 months' notice, given by either party. Clause 5 on page 509 requires removal of the drain on termination. One also sees on page 507 at J, clause 1J, there's an obligation not to assign, which is somewhat inconsistent with this simply being a statutory consent, we would respectfully submit.
Sorry, which page was that?
It's on page 507.
Thank you.
J is not a.
Well, you can demise easements. Why is this not a demise of an easement?
Oh, it is. I didn't say it wasn't demise of an easement. I'm saying what it isn't is a statutory consent because
You said it's called a demise, but did you dispute that this is a lease?
I wasn't saying called as in purports to be a demise. It's actually called a demise, which again we say is inconsistent with it being a statutory consent. The nature of the relationship, which is being described, is that of a demise. I wasn't being pejorative in the use of the word call.
Is there any difference between a lease of an easement and a grant of an easement for a term of years? I mean,
No. Well, of course one can grant an easement for a term of years. There's absolutely no issue about that. Then the next agreement is on page 514. Manchester Ship Canal Company to Runcorn. Relates to the outfall called Outfall 36. There's an issue over whether it does apply, but that's not for this court. On page 514, there's the demise, again in terms of demise rather than statutory consent, permitting various sewers to be constructed, storm overflows to be constructed from those sewers and for discharges to be made. The term and the addendum are at page 516. It's a 99-year term. One goes to clause 4 on page 522. There are provisions for termination on default.
but not on notice.
But not on notice. This is a fixed term. So this one hasn't been determined yet. But I think this one is said not to apply. But one sees there the provisions for termination. At 519, going back again at 2K, there's a restriction on alienation.
Which outfall is this one?
This one is 36, though there's a dispute as to whether this is the relevant agreement, or the next one I'm going to come to, which is at page 525. As Mr. Hart indicated, indeed, rather Mr. Morgan indicated in his submissions, there's some dispute over which sewers the agreements relate to. The next one is at 525. It's a 1987 agreement. The 87 agreement grants the council the right and liberty to discharge by various works in return for an annual rent. Again, at 525,
that's a term of 15 years.
it's a term for 15 years unless determined by either party giving the other not less than 12 months notice in writing.
Well, it's fixed term of 15 years and then thereafter a year.
Yes, then on notice, exactly. Then a clause 2F, there's the provision for reinstatement on or following termination. The 15 years has indeed expired, so this is one of the ones in issue, as to whether or not there's an extant claim. There's also a restriction on alienation in this agreement at page 528 at clause 2L at the top of the page. And finally, in the bundle, for present purposes, there's an agreement dated 24th of April 1933 at page 541. This is the one that relates to outfall 67. There's a grant to the corporation in consideration of an annual rent of £8, a privilege and licence to construct a stormwater overflow sewer, and on the same page there are provisions for termination. So with those agreements in mind, I propose to develop my analysis in 9 short, some of them very short, submissions. The first submission is a submission adopting a point made by my Lord Justice Nugee to Mr. Morgan. In essence, it is that a local authority can only do that which they are authorised expressly or impliedly to do. While it's a trite proposition, we respectfully submit there's a case which succinctly and elegantly summarises that proposition. The ex parte viewings case, which is in the bundle at Authorities Bundle 2.3, at tab 45, that starts at page 540. The facts of the case don't concern us. It was a case of whether a local authority properly take a decision to ban hunting with hounds on its land, but the relevant passage is at page 545.
I'm sorry, I have the wrong... could you give me the reference again?
It's at page 545 in volume 2.3.
No,
No,
it must be 2.2, I think.
but it's not 2.2 either if it's
Oh.
tab 45.
Perhaps I've got the tab. Oh, it's tab 47. So I haven't got the tab, so
So
it's page 540.
47,
I'm
it's
sorry.
back in 3.
It's the first authority in Authorities 2.3.
So this is viewings.
It's viewings. The only reason we need to look at it is the passage at page 545, which I submit summarises the proposition in elegant terms. The second submission which I make is this, that in order to enter into an agreement, local authorities must have been granted a statutory power to enter that agreement. That follows from my first submission. Nowhere in their grounds of appeal or skeleton did the Ship Canal Company identify those grounds. They now refer to section 14 of the Public Health Act 1875 and successor provisions in the 1936 Act. It won't make it, it's probably sensible to turn those up in volume 1.1 of the authorities. At page 30, we respectfully submit it makes no difference whether the agreements were entered into under section 14 or under implicit powers, as we say in our skeleton. We say, in fact, Section 14 is directed to the acquisition of existing, or rather, the acquisition of extant rights. That's the purchase of extant rights. But if my learned friend is right, it makes no difference. We submit that there would have been powers to enter into agreements, but they would have been necessarily ancillary to the pipe laying power. We refer in our skeleton argument to the well-known case of North Eastern Railway, which I needn't detain the court with. It's common ground that local authorities will have implicit those powers which are necessary for the performance of their duties, and entering into agreements can properly be described as within their powers if necessary to the performance of their duties. So I make no complaint that agreements were entered into. However, and this is the...
Is it a general principle that if you have powers of compulsory acquisition, you can do it by private treaty?
Well, normally, in statutes which provide for compulsory acquisition, there is also a corresponding provision allowing the same to be done by agreements. I can't think of at least a modern statute where that isn't the case.
We were told there are powers of compulsory acquisition in the 1875 Act, so...
But I'm not sure that there are...
Does anything express about...
No, I don't think so. I don't think anybody's identified any. I'm sure Mr. Morgan would have identified them if he were able. I think
it doesn't incorporate lands clauses, consolidation act, or anything
no.
like that.
We don't have that. I think.
Thank you.
So the third submission we make is whether one's looking at section 14 or the implicit power, if and to the extent an agreement was entered into pursuant to the statutory powers, implicit or express, they could only contain a provision for stopping up the sewer permitted by the agreement if there was some sort of implicit power for them to do so under the legislation. We say, if and to the extent that such power can be implied at all, it must be subject to the express limitations on the powers of local authorities to stop up sewers. At this point, we can turn up, since we've got the bundle open, section 18, which limits circumstances in which sewers may be discontinued until alternative effectual sewers have been provided.
Do you accept that the validity of the term... Your case is that when entered into, these agreements contain termination provisions, and those termination provisions were ultra various?
Yes.
Do you accept that question has to be determined by looking at what their then varies were
Yes.
under the 1875 or 1936
Yes, that's our primary case, and that was the way that the court decided it at first instance. The court didn't go on to decide our alternative way of putting it, which we put in our respondent's notice, which will be my 9th submission. But the primary way we put it is that the judge was right, and that's what I'm dealing with in my first 8 submissions.
So you say that if it's an agreement entered into before 1936, so it's governed by the 1875 Act, it's contrary to Section 18.
Yes, it conflicts with Section 18. There's
Can I just test that? Because what Section 18 says is that you can discontinue a sewer. It's true, it says it's on condition you provide another one, but why can't you agree? Take a case of a fixed term, 99 years. Why can't you agree, I'll have a 99-year lease? I know that in 99 years' time this is going to come to an end, so all I've got to do is sometime in the next 99 years provide a replacement sewer. I've got plenty of powers to do it. I've got Section 15, 16, 17, all the powers I want to do it. So why can't you agree to do that?
What one can't do as a result of this, if we say it is necessarily implicit, one can agree to do that, but if at the end of the period one hasn't provided it, one cannot lawfully stop up the sewer unless one has satisfied the condition. So
you put yourself in breach of contract, but it doesn't mean the contract's not one you can't enter into.
But what one can't do as it follows, however, in my respectful submission, that the contract cannot sit with the statutory power, because the power is subject to an express provision which makes it impossible for the local authority to exercise its power to stop up unless the condition is satisfied.
But it's within the power of the local authority to satisfy the condition. If I have 99 years to build a replacement sewer, I mean, at the date of 1875, you don't need anybody's consent to build a sewer unless it's within those protective clauses. You don't need planning permission. There's no planning permission. You've got power to make a sewer under Section 16. So why is it not entirely consistent with the 1875 Act, including Section 18, for a local authority to say, well, I'll have this sewer for 99 years. I know that at the end of that I'm going to have to provide a replacement one, unless I can negotiate an extended lease. But I've got lots of time to provide a replacement one. What's unlawful about that?
Well, we need to go back to the first two stages of the argument. First of all, the local authority only has power to enter into an agreement enter into agreements which are, by their nature, necessary ancillary to the performance of their statutory duties or the exercise of their statutory powers. There is nothing in the legislation which authorises a local authority to agree, anywhere in the legislation, to agree to stop up a sewer otherwise than in accordance with Section 18. My learned friend it's not for me to show rather than put it this way, unless it can be shown that there is a power necessarily to enter into such an agreement, necessary to the performance of the duties, then there is no authority to enter into an agreement providing for termination otherwise than in accordance with Section 18. There would be nothing to stop a local authority entering into an agreement conditionally to stop up a sewer. The problem we have here is that there is an absolute obligation to remove the sewer. It's not that I would accept that if it would be perfectly possible to devise a termination provision which would be consistent with Section 18, and that could, on the face of it, be regarded as an agreement which was consistent with the performance of the functions, powers and duties of the local authority. But that's not this case.
Can I ask a question about that? Why is it not the case that consistency with Section 18 depends upon the facts at the relevant time?
Well, consistency with Section 18 depends whether or not an agreement is authorised, has to be determined at the date of the agreement. Our case is that in the absence of express or implied authority at the date of the agreement, to enter into an agreement unconditionally to stop up a sewer, such an agreement at the date of the agreement is void. One cannot do that. That can be contrasted with the
Well,
position.
I understand the way you put it.
Yeah.
Let me just put this. I think it's the same point, but I'm going to put it again. It would have been lawful for the local authority under the 1875 Act to enter into a contract saying, we agree to remove, and we agree that before removing we will comply with our Section 18 duty of providing a substitute sewer.
Well, I wouldn't. No, that's not the way I'd put it. I would say that we will remove the sewer, provided that first there's been the effectual alternatives have been provided.
Now, I understand why there are difficulties today in providing replacement sewers, because they're exactly the same difficulties as you've addressed on the main appeal. But I don't understand why there were the same difficulties in 1875 to agree to provide a replacement sewer when Section 15 gives powers to make a replacement sewer.
There are powers to make it, but whether or not in any given, well, it's not just a replacement sewer. One has to provide, depending on the facts, at the time as they exist in the future, something which is as effectual, and one doesn't know what the constraints may be at that time. We're dealing here with the Manchester Ship Canal. We're dealing with drainage into the Ship Canal. It could be somewhere else, but we're dealing with a water catchment area. There is one place into which effectual drainage from that catchment area can be provided. So, even in the 19th century, one's in any given situation, the provision of an alternative for development in the proximity of the canal is going to be constrained. And it is not always going to be possible to provide such an effectual alternative.
I have not quite understood why not. Let's take a case where next to a canal, a development of houses is built in 1916. It's got a drain somewhere. You're right. The obvious place to drain into is in the canal. So the local authority asks the canal, and the canal reaches an agreement on payment of a yearly rent of 1 guinea. When that comes to an end, the local authority knows that it has to discontinue, because that's what it's agreed to do, and provide a substitute sewer. The obvious thing to do is to go back to the canal company and negotiate an extension of the lease, maybe on increased rent. If the canal company won't play ball and won't agree to that, the local authority has compulsory powers. It has a right under Section 15, a statutory power to discharge into the canal. Build a sewer and discharge into the canal. So it says to the canal company, well, if we can't agree, we'll exercise our statutory powers and you can get your compensation under Section 308 and we can have an argument about that. But there's no difficulty in providing a substitute sewer, is there?
There may be a difficulty in providing a substitute sewer. There would be no, subject in these days.
No, we're not talking about these days. We're talking about at the time the contract's entered into, was it something the local authority could agree to do? And at the moment I'm having difficulty in seeing why the local authority couldn't agree a time-limited sewer on the basis that when that comes to an end, they'll provide something to replace it, which is their duty under Section 18.
The problem isn't simply with termination. The problem is the obligation.
There's an obligation
the
to
problem
remove.
is the obligation to remove. Now, in the 19th century, it might be possible. It might be that, depending on the constraints, the most effectual alternative to the sewer here is, in fact, the sewer here, and they could then use their pipe laying power to say, in fact, they might be able to rely upon their statutory right of discharge and their pipe laying power effectively to relay the sewer here. But that is nonsensical. The problem we have is that there is an obligation in the meantime to stop up and remove the existing sewer. We say that is fairly and squarely at odds with the precondition in Section 18.
May I throw a slight spanner in this works? I'd be grateful if you'd explain, in relation to Section 18, it says, may discontinue, close up or destroy any such sewer that has, in their opinion, become unnecessary.
Yes.
But we're not talking about a sewer which has become unnecessary at all.
No. Yeah, I'm not sure it's a spanner in the works. It may be my get out of jail free card, my lady. I've been focusing on the latter bit of which is expressed conditionally. But
before you get to that,
yes.
Is this a power which could be exercised in these circumstances
at all? Because on the face of it, if the sewer were necessary, if it was still performing a function, it would be difficult to say that it was unnecessary. In many cases, of course, it might be on the fact that it fall into desuetude, which case.
But the discussion that you've been having with my Lord Justice Nugee is on the basis that you want to continue to drain, and therefore you're wondering how you're going to do it once you've got to stop up under the licence.
Yes, and
so it's not unnecessary at all.
Yes, indeed, and of course it's a matter for us to decide. It's our judgment as to what is necessary. And on the face of it, an absolute obligation to remove unconditionally is inconsistent with the way that Section 18 works. Both limbs, both the precondition about the sewer becoming unnecessary and the provision for providing an effectual replacement. There's no express power, and given the express terms of Section 18, we respectfully submit there is no implied power to enter into such an unconditional agreement of the sort that has been entered into here.
Sorry.
I was going to say that, if I may say so, is a very nice point, my ladies, which may be a great help to you. It doesn't apply to the 1936 Act, which I've just looked at, which is Section 22. It doesn't have the same wording. I mean, we've rather been assuming that the 1875 and 1936 legislation has the same effect, but this one simply says that you may discontinue, either entirely, or for the purpose of foul water, or for the purpose of surface water. It's on page 47.
Yes, I am. I have it. But again, although the point is not as strong, Section 22 provides for a discretion for the local authority to be exercised in the future. It may. The nature of the agreements is that it deprives the local authority of that discretion in the future to make that decision.
They must if the agreement is terminated.
They must, exactly. There.
So this is a question of fetter on your discretion.
Yes. Well. First of all, even before one gets to fetter of discretion, where is the power to enter into this agreement? We say, where is the statutory power to enter into an agreement? That's the first question. If there is to be an implicit power, we say it looks as though the power is implicit. The implication can only be that agreements can be entered into where they do not fetter statutory discretions. If we're in the area of section 14, which was raised by an old friend, Mr. Morgan, any power to enter an agreement there must itself be a power consistent with the exercise by the local authority in the future of its statutory discretions. And on the face of it, as the relationship has pointed out, the obligation is an absolute one to remove. So that's the way we put it. There is an inconsistency.
And so I'm sorry, I'm being slow. How do you say that section 15(1) little 3 dovetails with section 22?
Well, we say section 15(1) little 3 of this Act, as section 14 of the earlier Act did, is about the acquisition of extant rights, as I think my Lord Justice Nugee put to Mr. Morgan, and that is the way my understanding is that it has been read. But if Mr. Morgan is correct, and this allows the acquisition of a right to use and agreements to be entered into ancillary to that right to use, regulating such rights to use, then any agreements ancillary to the right referred to here, which allow for the stopping up of the sewer, would need to be consistent with the Act and could not better discretion.
In 22.
Yeah, 22. And similar interrelationship between section 14 and section 18 in the 1875 Act.
Thank you.
The point, in essence, is that any provision which enables authority unconditionally, regardless of the circumstances in which it finds itself, to stop up a sewer otherwise than in accordance with the statutory provisions is there is no power in the Act to enter into such an agreement. And my fourth point is that it doesn't avail the Ship Canal Company, as it did at first instance, to characterise the agreements as statutory consents, even if it were open to them to do so on the pleadings, because there is nothing in the provisions of section 327 of the 1875 Act, or section 332 of that Act, or 331 or 333 of the 1936 Act, where consent is required. There is nothing there, again, to suggest that those consents can be made subject to express provisions overriding the future discretions under section 18, the preconditions in section 18, or the precondition and discretion in section 22 of the 1936 Act. It doesn't get the Ship Canal Company home, even if it were able to categorise these as statutory discretions. We, of course, say these do not look like statutory discretions at all. We'll come on to that.
Statutory consents.
So statutory consents at all.
But I mean, does it matter? I mean, in one sense, they obviously are a consent. I mean, the Ship Canal Company did consent to the discharge under those licenses and leases. So your point is you can't have a consent which you can take away on terms that you have to stop up, because that's inconsistent.
Well, an absolute term to stop up, which fetters our discretion. So it's a fundamental principle of local authority law.
So I don't understand. I thought this was a different point rather than the same point.
Well,
is your point simply that the documents don't refer to the statute?
Well,
because otherwise, that's repeating your point number 3.
Well, the point is a separate. The point is a separate point. At first instance, it was decided the argument which proceeded was on the basis that these were agreements somehow apart from a purported statutory consent. I'm making the supplemental point that if it's open to my learned friend to argue that these are statutory consents, it, as your Lordship points out, doesn't take them any further, because there's an express provision, yes, things can happen with consent, but there is nothing within the provisions relating to consent which allow those consents to provide either for stopping up, but if something is to be implied in relation to ancillary matters, conditions attached to those consents, any such condition cannot provide for the overriding of the fettering of the discretion inconsistently with the stopping up provisions.
Right, so in other words, your point is a negative one, namely that characterising them as statutory consents, you say they can't and it doesn't work, but even if they could and it did, it wouldn't make any difference.
It wouldn't make any difference to this point. We've referred to a case in the skeleton arguments, the case of Kilby, in a very different context. I needn't take the court to it. It's a very simple point. One can't use a statutory power, which the statutory consents would be, to in a way that is inconsistent with the primary provisions of the Act. And we say here, Section 18, the 1875 Act, Section 22, the 1936 Act, are primary provisions. So any consent given under the provisions for the protection of owners of watercourses could not be exercised inconsistently in the same way as the submissions I was making in relation to agreement. So your Lordship is right, I make it as a negative point.
Do you accept that consent was needed? That the Manchester Ship Canal Company enjoys the benefit of those protective provisions?
Consent would only be needed if there was injurious affection at the time. I think that's right. We go to page 37 of the bundle first of all.
Section 3274. Injuriously affect.
Yeah. And one finds that falling through and following through into the 1936 Act. We simply don't know about the sufficient factual circumstances to know whether these were statutory consents. And that'll be one of the points I come to or purported statutory consent. One of the points I come to when we look at whether or not the amendment should have been allowed. But we say or there wasn't an amendment. If the point was allowed to be argued, there wasn't an amendment. We say even if consent was required, it doesn't get them home, as I've just explained in answer to the question of my Lord Justice Arnold. My lady, if I can go on to my next submission, I think I may have conflated some of my submissions now, but I think we call it the next one in any event. If the submissions so far are accepted, then it follows, to the extent that the agreements require the unconditional cessation of the use of sewers upon notice, they are ultra vires and void because the local authority had no power to make such agreements. And if categorised as consent, such a condition attached to a consent could not be a consent for the purposes of the statute. The consequence of an ultra vires act in this way can be seen from the school facilities management case, which we've included in the bundle, volume 2.5, at tab 65 at page 1175. I hope it's the right tab number.
Yes.
My lady, it's, the facts needn't detain us long. It was a case about the construction and hire of a school building. The issue was whether the construction contract was binding on the college. It was argued that it was not, because the contract amounted to borrowing precluded by statute because of its terms, and it was held that the contract was without the powers of the college, but the contractor had a claim in restitution. So I needn't detain the court with the details of the case. Mr. Justice Foxton summarises the law at length from paragraph 109 and following, starting at page 1207. We're going 1209 is probably where the best place to start. But I don't propose to take the court through a review of the authorities. I rely on the case for the succinct statement of principle which follows from those authorities at paragraph 150 and 151. It is clear that if a public body lacks statutory power to enter into a contract of a particular kind, then it will not have contractual capacity to do so as a matter of private law. As Lord Justice Hobhouse noted, public law, though through the construction of the statutory regime, answers the question, what is the capacity of the public body or to contract? And then private law provides that the consequence of that lack of capacity is that no contract comes into existence. The difficulty comes when addressing cases in which the public body has capacity to enter into a contract of a particular kind, but the way in which it has taken the decision to do so can be impugned on public law grounds. The authorities offer conflicting views on that issue and provide no answer which is binding on a first instance judge. these circumstances, it is necessary to approach the issue from first principles. But we say we are in paragraph 150 because there is no power.
Why? Why? I don't understand that, because you're not saying that the local authorities had no power to enter into these agreements at all. Your case is all about the termination provisions.
Well, they had no power. They had no power to enter into the termination provisions. Now, I'm quite happy for it to be said that the whole agreement was void.
It's not a question of happiness. That has to be your case.
Perhaps I'll explain. Perhaps I'll explain why I would be happy, my lord. I would be happy because if they were void ab initio, which might be one of the consequences, we would be able to plead. Prescription because, amongst our numerous other defences, because the discharges would have continued without any right at all during a prescription period. However,
I'm sorry, Mr. Harris, I'm completely baffled by the way you're putting your submission.
Well,
it's not a question of how your case is characterised, it's a question of what is your case. It is you who are advancing an affirmative case here. You're not responding to some case made by the other side. It is your case that they were ultra vires.
Yes.
Now, on a simplistic analysis, the consequence of the purported act of the local authority being ultra vires is that the act is void, and it's void ab initio, as in its entirety. And that is a case that is perfectly straightforward to understand. Where I have difficulty in understanding your case is insofar as you say that the contract is good in parts and bad in parts.
No, my lord, I don't need to go so far as to say whether or not a blue pencil test is possible in this case. All I need to do and all I have needed to plead is that we cannot lawfully be required, in reliance on these agreements, to stop up the canal, because to the extent that these agreements require that, they cannot be enforced. Whether or not it's because they are void entirely, as I've indicated to your lordship, I'd be happy with, or whether or not it is because a blue pencil test can be applied, leaving the rest of the agreement in place, but simply the termination provision, the termination provision voided. I'm happy either way. I do not need to have that decided because I make no bones about it. Whichever solution is adopted, whether the blue pencil test or whether the whole thing is void ab initio, either route can be argued for, but I submit both routes lead to my conclusion, and both routes, but a third route that somehow these provisions can remain enforceable against us from the start cannot be correct. So I don't need the court to make that determination on the extent to which a blue pencil test can be applied to these agreements.
You say, therefore, there was no power to enter into an agreement which meant that you had to stop up in a way which would be contrary to the sections we've looked at. That either has the effect that you couldn't contract on these terms at all, or alternatively, you could, but you couldn't include the termination. And you don't care. And
I don't get it. It's an interesting point, but not one that the court needs to
But
decide.
in relation to the second avenue, presumably you're going to deal with I think it was Stourcliffe, the case where I think it was said you can't keep the bits you like and jettison the bits you don't.
Well, Stourcliffe is if we can.
don't let me take you out of course,
Well,
as long as you go there, because I'm puzzled by that.
Southcliffe was a very different case. Perhaps I'll deal with that at the
appropriate moment.
Appropriate moment.
As long as
You said we don't need to decide it, and I can see that for these purposes you don't. In theory, it makes a practical difference to the extent of 5 shillings a year, because either you're still liable to pay rent or you're not.
But that may be the case, but that isn't the issue in these proceedings. The only issue is whether or not.
I mean, it seems a bit unsatisfactory that we're being asked to investigate the lawfulness of this provision and not being asked to put it in the box, the whole contract is void, or in the box, the contract is valid, but the termination provision is void. But you're not asking us.
I don't need to ask the court to make that decision.
We'll just leave that in the air if we're otherwise with you.
I'm quite happy for that to be yet another issue in this case. But
if you really want to litigate about 5 shillings a year, you can do so. It's
not whether we would want to. It's whether the Ship Canal Company would want to. Yes, Mr. McCreth points out that the judge left the issue in the ether as well, and I respectfully submit it's. I suspect nobody's going to fall out, even between these parties, over 5 shillings a year.
I think you're on your 6th point.
The 6th point. We say, in essence, it follows from that, if the agreement or this clause, whichever way one looks at it, is void, obviously this provision requiring removal and a cessation of our rights can't be enforced, and this was our point. We've cited the case of Birkdale District Electric Supply Company and Southport. I don't propose to take the court to it. We submitted it. It's a clear point. So the position is this: we're left with agreements. Either they're void or there's no lawful term for providing for termination. And because termination provisions are void, we say we're entitled to continue to discharge either under the terms, if the agreement is itself, it is only the termination provision that is blue penciled, or under our pre-existing statutory rights or entitlements, if they were void ab initio, because we would be in no different position from an undertaker using outfalls pursuant to its pre-privatisation, pre-1991 right to discharge. Either way, we are entitled to continue to discharge. The last submission, as I said, I think I've conflated some of them before I come back to the Stoercliffe case and finally the pleading point, is that we have an alternative way of putting it. And the starting point is the Supreme Court's decision in the present case. And we put the case in our skeleton argument, and it's possibly easiest to follow the argument through our skeleton argument, which is in volume 1 of the core bundle, tab 9. Paragraph 40. summarise the effect of the two analyses in the judgments of the Supreme Court. There are essentially two routes through which pre-existing entitlements to discharge survived. The assumption route, which was based on an absurdity of sewerage undertakers having vested in them infrastructure which would become unlawful, and the Lord Neuberger route, which construed the provisions as providing that our pre-existing rights to discharge passed to us through the transfer schemes when read with the Interpretation Act. We say, in essence, the point we make, the essence of this alternative analysis, is at paragraph 44. Of the skeleton argument on page 136. Where we point out that there is essentially the same absurdity in this case as there would be in the case where there was an immediate entitlement, an immediate unlawfulness. We've set out the passage from Lord Sumption's judgment, where he says, in my opinion, when the Water Industry Act 1991 imposed on the privatised sewerage undertakers duties which they could perform only by continuing for a substantial period to discharge from existing outfalls into private watercourses, at the same time applied the statutory restrictions on section 116 on discontinuing the use of sewers, implicitly authorised the continued use of existing sewers. A restriction on discontinuing the use of an existing sewer until an alternative has been constructed is not consistent with an obligation to discontinue its use forthwith under the law of tort. The inescapable inference is that although there is no provision of the 1991 Act from which a general right of discharge into private watercourses can be implied, these rights of discharge, which are already accrued in relation to existing outfalls under previous statutory regimes, survive. Now, of course,
how does that reasoning work if there is time in which to construct an alternative?
I was about to explain that, my lord. That the point is this: although some of the agreements were lengthy, some of them were determinable on 6 months' notice only. As Lord Sumption points out, the way he came to his conclusion using the first passage which we've underlined, that when the Water Industry Act imposed on the privatised sewerage undertakers duties which they could perform only by continuing for a substantial period to discharge from existing outfalls into private watercourses. And of course, in a case where an outfall can be made unlawful by service of a notice, even actually before privatisation, the notice might have been served before privatisation only to expire afterwards. It might be expired on the day of privatisation. The absurdity arises in the same way. It's entirely contingent on whether notice has been served. We say the same reasoning can apply. That's the way we put it.
But it's also contingent on how long it takes to find an alternative,
Well,
surely.
Exactly. And that's an additional point, because if, of course, it takes longer to find an alternative, we'll have a longer period of unlawfulness, and that reinforces the point that there's an absurdity. So yes, your lordship is quite right to make that point. Mr. McCrath prompts me to make the point, which is implicit, explicit in Lord Sumption's judgment, that the cure could indeed end up being worse than the particular problem. We'd end up with sewers that were unlawful on privatisation, contingent upon whether or not notices had been served. So it's the same reasoning, albeit on not such a grand scale as applied to the infrastructure where there wasn't agreements. So we rely upon this as our fallback position, even if the agreements had validity. But we say, for the reasons I've given, not. Now, if I can just, I think that is really all we have to say, subject to just looking briefly at Sturcliffe, which is at volume 2.1, tab 32. Page 161, I think. My lady, this was a case, as your ladyship's picked up, where there was a purchase of land by a local authority subject to a restrictive covenant restricting erecting certain buildings, any buildings. It was said that this was inconsistent with their powers under the Public Health Act to construct urinals, etc., on land. The reason, in that case, the council took the point was because they wanted to construct urinals on the land, which would be in breach of the restrictive covenant, and they sought to argue that they weren't bound. The ratio is on page 168 of the bundle, and it turns on the construction of the particular legislation. And it was held, we say in essence in this sideline passage, that there was no inconsistency between the power to construct urinals and an agreement not to do so in particular cases. That isn't our situation. We say on the construction of the particular act here, there is an inconsistency because we're required to do something inconsistent with our statutory discretion and inconsistent with the precondition, potentially inconsistent with the preconditions to when sewers can be stopped up.
Sorry, why was the corporation in this case not fettering its general discretion, and why was that not ultra vires?
Well, because in that case it had a general power to enter to acquire land, and in this particular case, it was on the construction of the provisions. It was held. It was able to enter into contracts to acquire land, and that didn't, on the interpretation of that particular legislation, preclude it from acquiring land subject to restrictions. It's a matter in each case of interpretation of the statute.
I understand that, but that's not quite an answer to my Lord's question. They had a discretion under a statute to erect buildings, including urinals. That's a statutory discretion. By entering a contract on terms that they're going to buy this bit of land and not put anything on it, they're fettering that discretion, but they're doing so lawfully. Every time a local authority enters into any contract, it's fettering its powers in some way or other because it's committing itself to a particular course of conduct. So what is the line between a contract which stops you from putting up a urinal, which is not unlawful, under contract which requires you to discontinue a sewer, which you say is unlawful?
Well, the case of the sewer, we're concerned with third-party rights, third-party entitlements, which are affected. So on the construction, we say, of this legislation, it would be inconsistent with the primary powers and duties of the local authority in relation to the circumstances in which sewers can be stopped up, for it to enter into an unconditional obligation to determine or to stop up a sewer. On the construction of this legislation, for instance, there would be nothing I'd respectfully submit to. Let's say there was an existing piece of land with an existing restrictive covenant between the vendor and the third party. There would be nothing to stop the local authority acquiring that land under this statute. There would be nothing to I'd respectfully submit ultra vires in them acquiring such land. So if one's looking at the purpose of this statute, there is nothing inconsistent with the purpose of that statute for them themselves in those circumstances to enter into such an agreement.
Can I put it this way? Suppose that Section 18 of the 1875 Act and Section 22 of the 1936 Act didn't contain the condition. It just said a local authority may discontinue any sewer. That's a discretion. Would there be anything then preventing a local authority from taking a time-limited lease or license on terms that it committed itself, when that came to an end, to discontinue a sewer?
In my respectful submission, yes. We need to go back to the four propositions I indicated to your Lordship yesterday, because the proposition is that once a sewer exists, a sewer is a sewer. It's once a sewer, always a sewer, until determined. I'll come back to that in a moment. And the public have a right to connect. And for a local authority in those circumstances, we're construing a hypothetical piece of legislation, of course. In those circumstances, assuming the hypothetical legislation contains similar provisions, for a local authority to agree in advance of all circumstances to stop up a sewer affecting third-party rights would be a plainly unlawful fetter of its discretion. The big distinction here is that this is infrastructure provided not just for the benefit of third parties in a general sense, infrastructure which third parties have a right to connect to and a right to use. That makes it a very different sort of statute from a case where a local authority has power for the public benefit to acquire land for public enjoyment and might only be able to acquire land subject to the restrictive covenant. We say in that sort of situation, it's a very different purpose, and the statute and indeed the restriction and the power to erect buildings for the public benefit is a very different power. Of course, there might also be a further argument as to whether or not the local authority could, in fact, in exercise of its powers, erect the buildings anyway, subject to the payment of compensation, because there is another principle in local authority law where development takes place in breach of a restrictive covenant, the restrictive covenant is overridden, subject to payment of compensation. But that wasn't argued here.
But your answer is simpler than that. It is these statutes are very different,
Yes.
and one has to take into account the nature of a sewer and the right to connect to it, which affects, I know it's putting it too wide, but the public at large,
Yes.
the public in the vicinity,
Well,
and therefore one has to take into account the nature of the right to stop up with regard to those rights of the inhabitants to connect.
yes, and one can go further than simply the rights of the those who have a right to connect, because there is a wider public benefit. Because of course, it is it is of enormous public benefit to have a robust and functioning, for public health purposes, if nothing else, sewerage system. It's a very different sort of situation from a statute, the same statute, public health legislation, which requires the acquisition of land for public recreation.
At the risk of unnecessarily complicating your case, when you were talking earlier about the impact of this being ultra vires, you said there were two options. One was to say the whole contract was void ab initio, and the other was to say the termination provision was void. Is there a third option, which is to say the contract's valid? The canal company can terminate in accordance with its terms. It's the covenant to remove and cease the use of it which is invalid. In other words, the rent might come to an end, all your other obligations might come to an end, but you can't be made to remove it unless you can do it consistently with what's now Section 100.
And that is essentially our alternative submission, because we say it would then be an absurdity given the provisions of
You'd have
Section
an implied
116.
right to keep it there, even if it wasn't a contractual right. You'd have an implied statutory right to keep it there.
Exactly, and that's the fallback position. So that is the third. Yeah,
That is
the third way is our alternative submission.
I see. Yes, thank you.
And unless I can assist your lordship any further, those are my submissions. Slightly longer than anticipated yet again, but I hope that was of some use.
Thank you very much. No. Mr. Hart.
We intend to take the same format as we took in opening, namely I will address the 2018 claim and Mr. Morgan will address the licences claim. And to that end, and before making my key submissions, which I think will be relatively short, I wanted just to pick up a couple of detailed matters arising out of the statutes to which Mr. Harris took you. And the first one was Section 1164 of the 1991 Act, which you will find in Bundle 1.1, Tab 12, 228. Is part of Section 116 that we spent a long time looking at. As Harris pointed out, subsection 4 of that, we simply wish the court to note, first of all, that subsection 4 was, as the notes make clear, inserted in 1992. So it was not inserted, it was not part of the 1991 Consolidation Act. And in my submission, it therefore can't be used to assist in the interpretation of the Act. Mr. Harris referred to the fact that here was a reference.
I'm sorry, Mr. Hart, I'm missing your point.
Yep.
Obviously, you can't use a provision inserted in 1992 to interpret the Act in 1991. Why can't you use it to interpret the Act now?
Because, well, you can, but it cannot assist the key question which is put against us, which is that the 1991 Act excludes, in effect, the common law rights. So we say you cannot say that this tells us what the intent of Section 94, Section 18, and the provisos, and how they all fit together. The other and detailed point is this, that the reference here to what's described as the director, I currently speak Ofwat, is determination under Section 30A. It's basically a dispute resolution between the undertaker on the one hand and any other person as to the effectiveness of the sewer provided by the undertaker. It's got nothing to do with Section 18, Section 94 or anything of that sort. So it really doesn't, we say, doesn't assist in the current interpretive set of questions. The second point I wish to refer to was in Section 95, which we can find at 162 of the same bundle. And you will recall the submission made by Mr. Karras that Section 95 was a significant pointer in the direction of excluding other remedies. And you will recall that Section 95 enables the Secretary of State to make regulations prescribing such standards of performance in connection with the provision of sewage services. That provision arrived in an earlier form, but in a very similar form, in Section 68 of the 1989 Act. And I hope the Court will have been provided with Section 68 of the 1989 Act. It's in similar provision, it's not identical, but the regulations making power is in similar form. And the Court will recall my point that at the time of the making of the 1989 Act, the provisos were still in the 1936 form. So we suggest that it cannot assist in interpretation of the provisos, because otherwise it would be, we say, rather extraordinary for the provisos to remain unamended in their 1936 form, and by reference to this power to make regulations, they are deprived of what we say is their common law force. We make the further point about Section 95, which is this, that the fact that Parliament has enabled the Secretary of State to make regulations of all sorts cannot assist in determining whether or not a right of compensation, and we say there was an existing right of compensation, had been deprived, because it simply did not, it did not say, whilst it's expressed in wide terms, it did not say anything indicating that it was likely to affect the particular common law claims under the proviso. So 2 points. One, it's in the 1989 Act. 2, it doesn't really tell us anything about the intent, the general intent of its inclusion. Section 95 was mentioned in Marchich, as you may recall from yesterday, and we should perhaps just remind ourselves of that. So, bundle 2.3 at tab 50. Sorry, tab 51. And we see the passage which Mr. Harris took you to, at page 640. And he drew your attention to paragraphs 44 and 45, and my point is a simple one. Apart from that, the reference there, it does not form any part of the reasoning in Marchich that section 95 is an important pointer. From those 2 points to our main point, we repeat our submission, which we made in opening, that the interpretive task does not start or end with Marchich, because Marchich was not considering the provisos as part of the statutory scheme that it was looking at. This court's role is we say, a different one, which is to say, given those provisos, given the history, given how it all fits together, what role do the provisos play in the whole of the statutory scheme? So the answer is not simply given by the conclusion in Marchich, which was not considering the provisos at all. We say that we say that the provisos need to be given significant content, and that Mr. Harris's arguments about what role they play do not give them content. And perhaps just the easiest way to remind ourselves of what he said was to take it from their skeleton argument, core bundle 1, tab 4, page 68. And at paragraph 49, he makes the 3 points which I'll deal with in terms. The first one is, it is said that the provisos make it clear that an undertaker had no defence under the statutory enforcement mechanism. So the undertaker, it is said, cannot argue if it's required by Ofwat to upgrade its infrastructure to avoid further such discharges, but what it is doing is authorised and hence immune. To which our submission is this. The argument that there was any doubt about it is, with respect, absurd. If there is a failure to drain under Section 94, then the undertaker is in breach of Section 94. That's plain on the face of that section. The Section 94 question is not, in fact, affected by whether the discharge was or was not within the scope of the statutory authority. It's a separate question. So to say that in some way you need the provisos in to stop an argument being made about the scope of Section 94 in those contexts, we say it's simply entirely unnecessary. If, second point rising out of this, if there was indeed a substantive change to be introduced by the 1991 Act, or indeed for that matter the 1989 Act, where you'll remember that the predecessor to Section 94 and the predecessor to Section 18 were enacted. If there was such a change, then you would have expected some sort of cross-reference between the provisos, their scope, and Section 94. If that's what the 1991 provisos are intended to do, it's extraordinary to leave them, so to speak, completely apart. If the statutory intent was to deprive the undertaker of that potential defence under Section 94. The second point that is made by Mr. Karras, the provisos are said to make it clear that an undertaker has no defence to any criminal prosecution brought by the agency for breach of a permit condition. We say again that has no content. The criminal prosecution, which was in Section 85 of the Water Resources Act, but then became part of the environmental permitting regulations, are simply amount to a effectively strict liability regime in criminal terms, and so it is difficult to see how provisos about a lack of statutory authority can possibly could even be thought to afford a potential defence to a criminal prosecution. And then the third point, which Mr. Karras makes, they remove any doubt as to whether a common law action might lie when there is no incompatibility between the remedy sought and the statutory regime. and perhaps we can link that to his paragraph 51, where it is said that the role of the provisos is considerably constrained in the Water Industry Act 1991 compared to the pre-privatisation legislation. And then what it said is that under that legislation, the predecessor of the proviso served as the basis of an implication that undertakers had a general right of discharge from any sewer they constructed. As held in that case, it is said, the proviso ceased to play that role, meaning that the undertakers no longer had a right to discharge from the sewers. To which the response is this: that's irrelevant. In the pre-1991 world, the implied right to discharge was held to be a consequence of Section 17 of the 1875 Act, as interpreted in Dunn and Frankson. So there was an implied right to discharge. In the post-1991 world, it was implied from Section 6116 by tort assumption. So what's the difference? In the first case, you've got one section, Section 17, which contains the in effect the proviso in the from which the implication is that there's a right to discharge. In the post-1991 world, the proviso was directly applied to Section 116 by Section 1175B. And I know we've been to that quite often, but it might be helpful just to go there once more. So, Bundle 1.1 at the proviso is at tab 12, page 230. And we can see from the opening words of subsection 5 that nothing in various sections or in sections 111 to 116 shall be construed as authorising. So the Lord Sumption route for the implied right discharge is section 116, and that is constrained by the proviso. In effect, that was exactly the same as the position under the pre-privatisation implied right of discharge via section 17 and Durrant. So the suggestion by Mr. Karras that the provisos, that the difference between the way in which the right to discharge was formulated pre-1991 and post-1991, that in some way that rids the 1991 provisos of their force. We say it simply does not stand up.
Well, that's not, my lady, that's not quite my submission. Well, the question is, what is the remedy for the breach? We accept that they do apply, but I don't want to take my lender friend out of his submissions, but he is, with respect, building a straw man. I don't think that was our submission.
I'm glad to hear that, but that's certainly how I've read paragraph 51 of this submission. That because of the changes in the way that Lord Sumption had formulated it, there was a difference. But as I've indicated in answering this point, there wasn't. It was exactly the same linkage, albeit using a different section to imply the right of discharge. And simply repeating the point that in 1989 we have the old Public Health Act provisos still in force. In 1991 they move into section 117 and 186 and we say there is no material difference in construing them. Can I just start on Marchich, etc., and see the time? But perhaps I can simply indicate this, that on reflection, having heard the debate yesterday, we do agree that, in effect, Lord Nichols's analysis wins effectively 4-3. I say 4-3 because, if you recall, Lord Hope expressly agrees with Lord Nichols, and then the other two judges who don't deliver substantive judgments, Lord Stane and Lord Scott, agree with both the judgments. So we accept that. But again, as I said in opening, that does not answer the main question, which is on a full reading of the statute, including the provisos. There is an intent to oust what we say is the ordinary meaning of those provisos, which appear to preserve such common law remedies as a claimant would have discharges which were on the face of it trespasses and nuisance. Would that be a convenient moment to break?
Certainly. Thank you, Mr. Hart. Two o'clock.